I'm Mandy Dendy. I work for Protection and Advocacy as a legal assistant, and I will be happy to provide you with my contact information. I believe it was on the web flyer in case you have any questions that come up afterwards or you would like further information. I'm happy to be your contact. There will be 3 presenters today. If you've seen the flyer, you will know they're Lisa Bjergaard and Karen Kringley and Carlotta McCleary, and they are all very wonderful presenters who will provide you with information specific to their individual topics. And so with that said, you will have an option to ask questions. You had an option to ask before the webinar, some of you who registered earlier, and we tried to get those questions answered for you. And you will have an option during the webinar to ask questions through the chat feature in MS Teams. You will not be able to speak, but you will be able to type them in. If you're unfamiliar with Teams, now that you're in here, there should be like a little chat bubble near the top and on a bar. And if you click on that, it will say show conversation. That's where you can type in your questions. I will be looking at those questions throughout the presentation and keeping track of them and then presenting them to our presenters at the end of their individual sessions. Each session may be roughly 20 minutes long with about 5 minutes or so for questions. And I'll be fairly firm on that so that everyone gets through, and we are done by noon. So if there are still questions remaining at noon, you'll have an option to email those to me and I'll provide you information afterwards as much as I can. So thank you for your time. We appreciate it. Waste any more minutes than necessary. Few other things, please try to limit your questions to the topics that the individual speakers are speaking on. So Lisa will be speaking on some background of this proposed bill, and Karen will be speaking more on the guts of the bill, kind of highlighting some of the changes that it may bring about. And Carlotta will be speaking to potential impacts or effects of the bill should it pass. And so our presenters may not be able to answer all of your questions, being as it is an informational webinar. If you have any questions that maybe go beyond the informational point, we will be gathering information and resources that we can turn you to find more information if you find we're unable to answer your questions today. So with that said, I am going to turn it over to our first presenter, Lisa.
Good morning. Thank you. And I want to make sure and thank Protection and Advocacy and Teresa for the idea of supporting a webinar this morning to just begin to get information on this important juvenile justice reform bill that we'll be hearing a lot more about as the session unfolds. So thanks again, Teresa, for this opportunity. My name is Lisa Bjergaard. I am the director of the North Dakota Division of Juvenile Services, which is the North Dakota's youth corrections arm of the executive branch. But I'm here today in my capacity as the chair of the Commission on Juvenile Justice and the work that has been done with the commission over the last interim. And so my job today is to set up for you the process that brings us to the point where we have a bill for consideration this session. And so I want to go back about 4 years now to 2017. And during the 2017 legislative session, the legislature created a Children's Behavioral Health Task Force, and at the same time passed an interim study of the juvenile justice system. The Children's Behavioral Health Task Force had a broad set of marching orders around looking at the needs of behavioral health needs for children in sort of all of their, wherever you might find them across the spectrum. And so it was a very broad group. I don't know that the group was broad, but the work that they were tasked to do during that interim was quite extensive. The interim study of the juvenile justice system got tagged kind of into that adult criminal justice reinvestment reform work that was happening on the adult criminal justice side of things. And so as the interim concluded, both the Children's Behavioral Health Task Force and the interim committee felt like perhaps they had not specifically addressed the issues of juvenile justice as well as they may have, as specific subsets of both of those branches of work. They weren't really talking to each other about that notion. The Children's Behavioral Health Task Force concluded that perhaps they should try to form something like an ongoing children's cabinet that might move forward and continue to look at juvenile justice concerns. And likewise, over in the interim committee, a couple of the members, specifically Senator Dever and Representative Lisa Meyer, both felt like they had not done what they wanted to do around juvenile justice during the interim. And so they also put forward a proposal. Their proposal was for a Juvenile Justice Commission. And so we entered the last session with these two bills, one that would form a Juvenile Justice Commission and one that would form a Children's Cabinet. And as that moved into session, that began to look very confusing to legislators who were going, okay, which one of these, what are you doing? What is this about? And so several of us worked together to put those bills into one bill then that was successful, was passed. And if you're interested in looking at where that legislation now lies, it is in Chapter 50-06, and the Children's Cabinet is 50-06-43.1. And the Commission on Juvenile Justice is Chapter 50-06-43.2. And so what you have is the Cabinet now, who oversees the work of a Commission on Juvenile Justice, who then reports their work to the Children's Cabinet. And you also have another arm of work under the Children's Cabinet, which is to set up a continuum of behavioral health services for children across the spectrum under sort of that other side. So the work really, we heard, had the privilege of participating in the Children's Behavioral Health Task Force, and we heard from many different areas of children's behavioral health, and realized that an interim was just not long enough to do any of those topics justice. And so the ongoing creation of the cabinet, I think, was quite an accomplishment for that Children's Behavioral Health Task Force, and really allowed us to begin shining a light on children. So the commission then was live July of 2019. And at the same time, another juvenile justice interim study was also passed. And so both of those things began their work then last July, in late summer. And it took, of course, it always does, a while for the membership of the Children's Commission. The Juvenile Justice Commission has 16 voting members, and they're prescribed in that section of law that I just mentioned to you. And so it took a while for Legislative Council to appoint their members, and for the governor to seek and appoint other members of the commission. And then the last thing that the governor needed to do was name a chair for the commission. And so once all of that had been done, the Juvenile Justice Commission met with that. I was appointed as the chair of the Juvenile Justice Commission, and I met with the chair of the Interim Judiciary Committee, who was also going to take a look at juvenile justice. And we decided that it would make the most sense to work collectively. Now, the Interim Judiciary Committee had a strong desire to create meaningful legislation for children and for juvenile justice going forward. Representative Larry Clamine was the chair of the committee, and he recognized as well that in the previous interim, perhaps not as much was done around children and children's issues as he felt was appropriate. And so he had a very strong desire to really dive into this topic and look hard at what we might do around juvenile justice. He had the additional experience and wisdom of having served for, it's over 20 years on the Uniform Acts Commission, which is a body nationally that is convened from all of the states that looks at various uniform codes that are implemented across states. And in North Dakota, we had adopted the Uniform Juvenile Court Act, and you'll still see that title on our Chapter 2720 today. And so he was very familiar with the Uniform Juvenile Justice Code. He was familiar with uniform acts and how they get implemented. And so he had that additional insight and ability to understand how those things at some point just outlive their usefulness and need to be updated. And so the Interim Judiciary Committee and the Juvenile Justice Commission started to work together. We approached another of the governor's boards and commissions. We approached the Juvenile Justice State Advisory Group because they are responsible for determining grant awards with some of the federal money related to juvenile justice that is available annually to North Dakota. And so we asked the JJSAG if they would fund a preliminary study to begin kicking off our work. And so the SAG did vote to fund an RFP that sought solicitations to do a preliminary analysis. The successful respondent to that RFP was the Council of State Governments Justice Center. Now, the Council of State Governments Justice Center had already done work in North Dakota in 2015, so they had familiarity with our system. They also were the entity that supported the adult criminal justice reinvestment work. And so they had boots on the ground in North Dakota for the last 5 or 6 years or so, and that really enabled them to put forward a good proposal. The other advantage to the Council of State Governments Justice Center work is that they have been involved in juvenile justice reform work around the country for probably close to 10 years now. And so they are able to access all of the best practices from around the country and what other states have learned as they've moved through this really lengthy process of juvenile justice reform. They were selected late in 2019. And so around the first of last year, they started their work in North Dakota. We had an in-person kickoff meeting in February, if you all remember, back in the days when we could get together and talk about things in person. And so members of the Interim Judiciary Committee, members of the Commission on Juvenile Justice, and members of the Juvenile Justice State Advisory Group met at the Capitol and had a discussion around the preliminary thoughts that the Council of State Governments had around how you might pursue juvenile justice reform work. The Council of State Governments then was tasked with creating some initial recommendations. They finished those recommendations in June, and they presented those recommendations both to the Interim Judiciary Committee and to the Juvenile Justice Commission. We decided that we should form, now this is June, so this is just a few months ago, that if we were going to have a bill ready, we really had to dive into some serious work. Fortunately, we were all cooped up in quarantine, and so we had the time to do this. So if there is a blessing in a pandemic, it was that we had captive audiences. And so we spent many hours via Teams in meetings just like this, really poring over Chapter 2720, trying to incorporate as many of the preliminary recommendations as we were able to. I think we added up about 40 hours of just small committee work where we just were meeting together in this virtual format. And then we broke off and did other drafting pieces on our own time. and we convened several times a week for several weeks. We presented that work to the Juvenile Justice Commission, but more importantly, to the Interim Judiciary Committee, who proceeded then to move forward with taking the work of the small work group and sending it up to Legislative Council for a bill draft. So the bill draft was finished this fall. And we all know, in fact, we were chatting a little bit via email last night. We all know that it's a long bill draft. And so there were things that we probably have to go back, and we found a little section that got dropped out last night that's really important that we got to get back in there, some of those kinds of things. So it's a work in progress. We'll move into session with it. I'm sure it's going to stimulate a lot of really good conversation, and we'll see where things go. But it's very, very exciting work. The Uniform Act was adopted in 1969, and code for kids in juvenile justice in North Dakota has not been updated since then. And this is now I'm moving into that, not fact, but my opinion. I don't think any of us want practices, policies, and procedures that we thought were relevant in the 60s to be used in working with our kids and families today. I mean, there isn't another. If we have certainly changed how we handle children's medicine, how we handle children's mental health, how we handle education. It's time that our code catch up as well. And so I'm so excited that there is energy and political will to do something for kids and families. This is the first time I've seen this much energy around this topic, and I'm really hopeful that we can move forward some significant code changes. You know, we can all point out gaps and problems in systems. It's very hard for systems to operate when their foundational enabling legislation is not adequate for the needs of children and families in modern day. And so if we want to fix some of those gaps and problems in our system, we have to fix their marching orders or their encoded authority first. And so that's where we're starting. And it's a big lift. And I'm excited for you all to hear more about it. That really concludes, Mandy, what I wanted to say. And so if there's any questions about that, I can sure take them. But I think it's a lot more exciting just to get on to Karen's meaty presentation about what's actually in the bill.
Thank you, Lisa. I don't see that any questions have come through, so I will just throw the ball over to Karen.
Okay, let me get my PowerPoint. One moment while I do that. Oh, and of course, when I pull it up, then it covers what I'm doing. Let's see, screen one. Okay, can you see my PowerPoint?
No, Karen, we just see the.
No, you just see that. Hang on. Gotta. Let me share my other. Try one time again. Better?
We can see it.
Small.
Yeah, I think my I think we're going to be stuck with that because of the way my screens are today. Can you see it well enough to?
I wonder, Mandy, if you shared yours, would it? And then you could just walk her through it too, Karen.
Yeah, I apologize. Working from home.
Let me see if I can get that queued up here.
We generally work in Zoom, so I'm less familiar.
Okay, let me go. Can you see that?
There we go.
Let's see. On our presentation here. Oops. I don't want that. I'm not sure how to tweak that setting. Does that work?
Yeah, I think so. I can see it anyway, if everybody
Okay.
else can.
Yeah,
I
it looks
apologize.
good. Yeah.
I'll try not to cover all the same ground at the beginning. So maybe you can quickly, can I control the slides or
I'll click through it here.
click through? The first couple of slides is the ground that Lisa covered, which just talks about the Commission of Juvenile Justice, of which I'm a member. I'm the director of Juvenile Court for Administrative Unit 2, which is the Southeast and the East Central Judicial Districts. So I cover the areas, the Fargo region, Wahpeton, Jamestown Valley City. That covers all the way, Napoleon up to Carrington, New Rockford, and Harvey also. So the 17 counties in southeastern North Dakota. And so my role this summer has been to kind of be as a practitioner representing the juvenile court and the work we do with kids. Are you able to advance it, Mandy? I'm sorry.
Do you want me to stop yet?
Am I not seeing what you're seeing, maybe?
Oh, let's see here. Let me see what screen I am sharing. Oh, got it. Okay. So I think I'm going to switch out what I'm presenting here. Okay, let's try this one more time.
I apologize. I was down to one screen today, so I'm a little.
Oh, no, not that one. I don't even know where that came from. Let's see here.
I can email it to you again.
Oh, I have it. I have it up. Oh, okay, wait. Here. No, that's my technical error here. I just didn't scroll down far enough, I think. That's the problem. Okay, let's see here. That is up. And so okay, just one more second.
Well, maybe, as you toggle a little bit, Lisa talked about the Council of State Governments making several site visits to study and meet with stakeholders in the juvenile justice system. And they did that over the months of March and February and again in May, virtually during the pandemic. And as a result of that, they issued 20, I think it was about 29-page single-spaced letter that had a number of recommendations for us. And so as we sat down to work on the bill draft, we took their 29 pages of recommendations and really tried to take our current code and add their recommendations. We weren't able to address all of them, and the Commission on Juvenile Justice is a 6-year commission, so we'll be continuing to meet. But the first task really for us, and one of their recommendations, was to pull apart the code, because as most of you probably know, Chapter 2720 combines deprived, unruly, and delinquent kids all in the same chapter. And so for brand new practitioners, whether it's social workers or attorneys or judges, you have to be able to read those statutes and kind of pull them apart paragraph by paragraph, sometimes sentence by sentence, to know if that sentence applies to delinquent kids or does this sentence apply to deprived kids. It talks, throughout, there'll be a statute on termination of parental rights, and then the next statute will be possibly about detention of youth. So it's a complicated setup. And so one of their first recommendations was really for us to take the code and pull it apart into subcategories. And so each case type gets their own section. And so that makes it a lot easier for brand new practitioners in the system. If you have a delinquency case, you go to the delinquency chapter. If you have a deprived case, you're going to be going to the child in need of protection section. So that was the first really labor-intensive thing we did in June, which was really just to pull apart the entire chapter. Some areas needed to be duplicated. The new setup, and as some of you may be aware, last session they passed a Guardianship of Minor Children chapter, and that is currently 2720.1, and that encompasses all guardianships of children except for those established under probate. So basically, the will cases are handled in probate and everything else comes to juvenile court now. That's 2720.1. So the bill draft itself will start with 2720.2, which will be called the Juvenile Court Act. And one of our major lifts was to update. As Lisa said, there haven't been a lot of updates to the statutory definitions, and a lot of our modern terms that we use in the practice of probation aren't in there at all. So we did a lot of work, and each subsection has its own definitions, so that you don't need to be flipping back and forth in the code. If you're working in delinquency, the definitions are at the front of the delinquency section. So as I said, the guardianship of a child will stay at 2720.1. 2720.2 will be the Juvenile Court Act, and it'll be general definitions and things that'll apply to the whole section. And then 2720.3 will be the new chins and chips section. The Council of State Governments recommended that instead of using the terms unruly child or deprived child, that we use child in need of services for unruly and child in need of protection for deprived children. And that makes good sense to me working in the field, because kids who are exhibiting unruly behaviors are kids in need of services. And so often, because of the way our code is set up, they're almost treated as delinquent children and can receive delinquent outcomes because it isn't clear in our code. And so kids who are running away or are disobedient of parents, are truant from school, are using tobacco under the age of 14, even the alcohol, minor consuming, minor in possession, those are considered status offenses, meaning they are illegal for you because of your age, if you're under the age of 18, and not because you're committing a crime, something that would be against the law for adults. So that's something new to kind of wrap your head around. There are other states that use those terms, but instead of unruly, if the bill passes, we're going to move to child in need of services. So CHINS is the acronym. And instead of a deprived child, the phrase will be child in need of protection. So CHIPS. And that'll maybe take a little getting used to, but I think words. And so I think using that child in need of services, it just puts front and center what we need to do, which is provide the child with services, and even in the deprived category, in need of protection. So it just puts safety at the forefront of deprived cases. So like I said, 2720.3 will be the chins and chips. Do you think, Mandy, I should just share my other screen, even if it's small? Is that better than?
It might be, Karen, because I'm having trouble sharing my screen at all now for whatever reason. I can't explain. I'm wondering if maybe Teams gave you control back to yours. So yeah. I'm not able to pop it back up in any way, shape, or form at the moment.
Yeah, I apologize. Let's see. Do you see anything? Do you see my slide?
Yes, we can see it.
Yay. Okay. So let me go back just a little bit here at the beginning. So yeah, I mean, just quickly, I'll move quickly, but it's a 6-year commission, and as Lisa said, it's established in code, the commission, and the goal of the commission is to review Chapter 2720. So that is specifically what we are doing. The council state governments gave us all of these recommendations. If you're interested in that document, I think we could make that available to you. It has lots of good recommendations. And this is the work group that was formed. So the smaller work group, which is a subset of the commission, was Representative Clamine and Representative Koppelman, Senator Larson, Senator Bakke, Lisa Johnner, Corey Peterson from DHS, myself, Travis Fink from Indigent Defense, and Tessa Vaughan from Burleigh County State's Attorney's Office. So we started working on it, and this is what I was just talking about, going from the current setup, which is that full Chapter 2720, followed by Guardianship, followed by DJS, into the proposed, which will keep Guardianship at the head. 2720.2 will be the Act. 2720.3 will be chins and chips, as I was explaining. 2720.4 will be juvenile delinquency. And then we will put the DJS chapter at 2720.5. So it'll keep all of those child-centered activities all together, and each section will have its own definitions. So just in general, we're really going to clarify roles and responsibilities. There were many areas in Chapter 2720 where it was almost silent and left for people to guess, like, am I responsible to serve this document? Am I responsible to prepare the petition? Many times as a practitioner, the statute didn't speak. That's not to say that the agencies involved don't have employee manuals and guidance. We certainly have over the years developed a pretty extensive employee best practices manual in the juvenile court, which if you're interested in, I would certainly give to you. And so that's what guides our employees, but our code hasn't been updated. Like I said, we separate out the sections by case type. And for me personally, the most exciting part is the broadening of the right to counsel for children. All children in a delinquency action will be presumed to have the right to counsel. So we'll be able to start off right away with counsel regardless of the parent's ability to pay or their circumstances. So many times in delinquency cases, we see that the parents wait a hearing or two before they know if they need an attorney. Sometimes the parents waive the child's right to an attorney. That's concerning for us when we have 14 or 15-year-olds waiving a right to counsel in a felony case, for example. So I'm really excited. I also think this will cut down on some court delay because we'll have an attorney right away instead of having that continuance to get an attorney on board. So I'm pretty excited about that. And we also see in the bill a broadened right to counsel for parents in a detention matter, which is a delinquency hearing. Also, generally, we added a specific statute on Indian child welfare active efforts, which is federal law, but we brought that into our state code to put that front and center for our state judges and our state's attorneys and defense attorneys, so that it's right there for those agencies what they need to do to prevent removal of an Indian child from an Indian home. So those are the general categories. In talking about, and here again, I'm talking about unruly section or the deprived section. We'll be using these new acronyms, chins and chips. The council state governments recommended that we decriminalize unruly teenage behavior, meaning pulling unruly behavior out of the delinquency section. And so here we want to make our primary goal is connecting those youth with the right services by using evidence-based assessments. And that is the goal of the CHINS section. And it also provides a really nice mechanism so that families can access services without having their child arrested or cited into juvenile court. Many times when youth are in need of services, people will be told, well, if your child was arrested or cited, we can get them into this program or we can get them access to these services. And you really shouldn't need to have your child arrested to access appropriate services. So the statute itself allows parents to call and access services without that citation or arrest. And like I said, there's some clarification here of roles. It does require more from the human service zones and the schools. Schools need to show what efforts they've made before they would make a truancy referral, for example. And we've never had a specific diversion statute, even though we have been diverting cases. We in fact divert about 80% of our unruly and delinquency cases to services without formal court involvement. But now we have statutory language that bolsters that best practice. So I made this slide just because I think this is an area of interest for people, but currently all unruly referrals are under the exclusive jurisdiction of the juvenile court, meaning they come straight to juvenile court. The bill draft has the categories of unruly behavior, ungovernable runaway, truancy, tobacco possession with children under the age of 14, and just generally children in need of treatment and rehabilitation. Referrals under the bill draft will go directly to the human service zones for assessment and connection to services. In the discussions this summer, it was decided that minor in consumption and minor in possession would stay as referrals coming to the juvenile court. We had some discussion about that because in the future, it could be that we would advocate to actually have those referrals also going straight to the zone simply for connection to services. But right now, our codes, even in Chapter 39, there's a number of driving penalties. If you're a driver of a motor vehicle while drinking or possessing alcohol as a child, there are reports to the Department of Transportation. Also, some of these, by keeping these with the court, children have the ability to deny the charge and contest the charge and have access to the court system. But that's kind of the division of what we would call the traditional unruly offenses. I kind of front and center so you could see that a little bit. If you're interested, last year in juvenile court, we got about 2,100 unruly referrals. And the most common is just this general unruly or the minor consuming. Some of those cases are kids who are delinquent at the same time. For example, if you are referred for theft while you were running away, you have both a delinquency and an unruly at the same time. And that will continue to happen. Those will be dual status cases, meaning you'll have both entities involved and will engage in multidisciplinary team meetings to see what's best for a child before moving forward. But I just kind of wanted to point out that it doesn't mean that the juvenile court won't necessarily be involved if there's a delinquent charge. Those charges will come to the courts. So I'm now seeing the team screen. Is that everybody else? Yes.
I'm sorry, Karen. I'm seeing if I can bring it up big one more time.
Okay, sure. Yep.
I'm going to request Control and C again.
Okay.
I've done that before. I feel like I should at least be able to get some kind of screen that's bigger than the one you're able to share.
Yeah, and my PowerPoint can definitely be sent out to everyone afterwards. Absolutely. So, and even then, if it were to generate questions for you, I'm happy to field those. Are you sending?
So I'm requesting Control. I don't know if you can give that to me or if Cheryl gives that to me.
It didn't pop up on my screen this time. Last time it did.
Okay. I think that's the snag as to why I'm not able to share that. Because I have the PowerPoint up on my screen, but sorry, it's just not working for whatever reason. Okay, I will let you go back and absolutely, we will email out the PowerPoint afterwards.
Okay. Let's try this again. Are you seeing my PowerPoint? Please say yes.
Yes.
Yes. Okay, great. It's really hard. This is a 120 some page bill. So honestly, to put like a summary of some of the changes onto a slide is a challenge, but here are some of the proposed changes to the delinquency section. There are limits to the use of secure detention. You may have noticed last session that we the legislature added the use of the detention screening tool, which is an objective screening tool to determine risk to public safety as a gateway to whether or not you are admitted to detention. The bill draft also adds to that some other limitations to detention, as well as eliminating the use of detention as a sanction for juvenile drug court. It also requires mental health and trauma screening upon detention entry. Here too, there's a statute specifically about diversion to services, which, as I say, is new to law, not to practice. We've always been a big diversion state. There are reduced lengths of probation and limits to the probation extension. So we don't want to just continually keep a kid on probation because there's delays in accessing services or minor probation violations. We want to connect kids and address their needs and then get them quickly off probation. It requires that delinquent dispositions be tied to evidence-based risk and needs assessments performed pre-disposition. The juvenile court has been using a validated risk and needs assessment tool. We've been using that since 2001, but that's been part of our procedure manual. It hasn't been part of code. And this specifically will require it prior to a court hearing so that the judge and the attorneys involved and the family can know what specific risks and needs are causing that criminogenic behavior, so they can address those things and not just address a wide group of things that don't drive the criminal behavior. Like I said, very exciting, the right to counsel for all children. Very excited about that. It also limits the use of probation violations as a basis for DJS commitments. So you can't see just, I'll give you the worst example, like curfew violations as a means to kind of bootstrap kids into the Department of Corrections. And it also it adds a definition of graduated sanctions, which we do use in probation, but it kind of brings that up into code. And then the bill drafts includes a sunrise clause that would add some limitations to school-based misdemeanor delinquent offenses, with some exceptions for like drug and domestic violence offenses. And this was, Lisa mentioned earlier, that we caught as we were looking through some of the bill draft language, that some of the multiple drafts we made over the summer didn't catch that. Right now, the bill draft looks to limit all school-based delinquent offenses, but it was really intended to limit infractions and misdemeanors without the school exhausting school-based services. So here are some of the potential impacts. You know, we think bringing all of these modern validated evidence-based practices into code is a great way to update and make it more clear to the practitioners what they need to do with each case. You can access services without being arrested and referred in the CHINS section. It's required by code to use validated risk and needs screenings and assessments to make sure that we match kids with the right services based on their particular needs. We're trying to really restrict the use of any unnecessary out-of-home placements and try to free up resources that we've used on the most costly end of the scale so that we can do more work up front in the prevention side. And here to increase public safety by making sure that the right kids, meaning the kids who pose the most danger of public safety, those are the kids that would actually see the inside of a detention center. And of course, ultimately improve all outcomes for kids and families. So that is my last slide. And now I can't try to look to see if there are questions.
I haven't seen any questions come through, Karen, but I'll scroll back up and make sure.
Sure. It's a very lengthy bill, and there's lots of nuance to it. There's still a lot of areas that we would like to develop. And like I said, the commission is a 6-year commission. We'll continue to meet until 2025 and continue to work on those areas. And yeah, I can see the question about a fiscal note. I know, for example, Travis Fink is working to come up with a fiscal note on indigent defense to see what costs there would be there. I don't know if Lisa Bjergaard is still on, but that's the extent I know about the fiscal side of it. I know I had mentioned to Mandy that the human service zones have been talking about what this will mean for them to handle unruly referrals. And it is a small number of cases, and they typically are kids that they are seeing anyway, kids that cross over these various lines. But Corey Peterson's been talking to all the zone directors about what the practice will be around that. Any other questions?
I actually have a question, Karen. I'm just curious, does this proposed bill look to tie together more entities that deal with youth? Does it look in any way to increase communication between these different groups and collaboration or information sharing to better help serve these youth?
I think that really is the goal, and you can see that in areas of the bill where, for example, requiring the schools to provide us more information about a youth before making a referral. Many times that's varied school district by school district, the amount of information we've received. So that's been important. I think also it'll require communication between the zones and juvenile court staff and the juvenile court staff and DJS staff as we work with kids and families in the system. So I think that was something the Council of State Governments noticed, that we all seem to operate in our particular little area, and we need to increase the amount of communication and have a common goal. We would really like to have the overarching goal be to look at kids in a developmental approach as we look at their needs. So yes, I think there will be more language added as we go along in years to come that way.
So a couple more questions have come in. Are there any detractors to the bill? And if so, can you summarize their issues? So anything that you know of that you can speak?
Maybe, I mean, it's a little early because you're actually the first group we've come to. So we're going to be meeting, Lisa can correct me if I'm wrong, we're going to be meeting with schools and with sheriffs and with state's attorneys. And, we're going to be working our way through the different stakeholder groups. I think there have been questions already about whether some of these changes, are we ready for them? Are the services going to be available? A lot of the services that have come through the juvenile court, well, how will that shift be? I think, there are going to be more prevention dollars with the family first dollars. So I think there are some questions about that. I don't know, Lisa Bjergaard, if you have other thoughts about what areas of concern there are.
I think that's a good summary. I think obviously the schools are concerned. I mean, I would be too. And like I said, we haven't got things perfect yet. We did discover some parts of it. I didn't realize, Karen, either that section on delinquency in schools just got omitted. So I bet that caused all kinds of panic for people reading it through. But we've got a lot of public education to do yet. The Council of State Governments is guiding us on that. Like Karen said, we're going to be holding a question and answer session with DPI and with the courts and with child welfare, with the state's attorneys and with law enforcement. I think some of those are already scheduled for the next couple of upcoming weeks. So we'll be getting out there with a lot more information, and our presentations will get increasingly polished as we start to see what people's interests and concerns are. Karen, I can't remember if you mentioned we delayed some implementation. Did you mention that?
Yeah, I did mention that there were a couple sections that are proposed to not go into effect until 2023, and that'll give time for more planning around services. So I think there is that intentionality. I think the one thing the pandemic has taught us is that we're doing so much through Zooms and we're doing a lot more mental health. The probation staff, for example, we're doing the vast majority of our probation meetings over Zoom. We're teaching cognitive groups over Zoom. And that's been a real bonus actually to rural areas where we've always struggled to get out to get a group of kids to run a cognitive group in a rural area. Now they can join in immediately. I think the timelines are faster. If you want to be in a victim empathy class, we've got one, log on. And so I think that's been a promising practice. We're doing our risk assessments over Zoom 3 times. So We have learned a lot in the last 8 months about how we can deliver the same services in every part of the state. And that definitely was a concern of the Council of State Governments, is that we shouldn't have, justice by geography, that the same evidence-based services should be available, just as much in Ellendale as they are in Fargo. And that has always been a concern of mine too, for as long as I've been in the system. Trying to look at a couple more of these questions. See, there's one about attending care. I think there are more discussions to be about attending care and how that'll be used. With unruly runaway youth, as the zones roll out their mobile crisis units this month of December, there will be, our understanding is a lot of public media that'll go out about the use of the mobile crisis units, and those will be available for families struggling with unruly teenage behavior or runaway behavior, that they'd be able to respond immediately to a home, either through tele or actually, getting in the car and going to the home, and that'll be available statewide. My understanding is that starts December, which is now. So we'll see as that goes forward, but that will be definitely an area that'll pick up where in the past they've needed to use attending care, they've needed to call the juvenile court in the middle of the night with those types of issues. And instead now of responding with law enforcement, I mean, they may still respond with law enforcement depending on the situation, but instead responding with social work trained people or behavioral health people to those types of crises. So I'm excited about mobile crisis units. I think that'll solve a lot of these areas. I think you may see some more uses of attending care as we really try to limit down the use of detention. So if kids are arrested for a delinquency that's low level and they don't pose a public risk, but we can't find a parent, we can't find someone to release a child to, there we could see some general addition to those attendant care uses.
I think, Karen, to your point about fiscal notes, those mobile crisis units, what's important about noting that is that is beginning this biennium. That's budgeted. So that's already funded. That's not something that has to be created in a next fiscal note. I also wanted to say that the intent with creating the children in need of services category was not to limit by those kids not going to court. It's intended to broaden families' access to family and other providers. So that anyone who has a concern about children that are in need of services is able to help that child and that family access services without having to route them through the juvenile court. So,
or to create a record, to create a record.
Right. So the intent of what we were doing was to broaden and open up and better support kids and families and better everyone's access, schools, providers in the community, everyone, to be able to get services for kids and families. Wasn't intended. It's I think I hear this kind of viewed as you've left us out of this. Now we can't get services. It's supposed to be the other way around. So I just wanted to make that point.
I see a question about impact of offenses due to behaviors in schools. I mean, I think that this is a topic, the school behavior topic warrants a lot of conversation. I mean, from my standpoint, working in juvenile court for 25 years, there's so many inconsistencies school district by school district. Some school districts I never hear from. Like they either have perfect children or they do a lot of their they handle a lot of their behavior issues internally. Other schools I hear from every day. So there's just just a wide variety there. And to me, it's a shame that a kid attending one particular school is all of a sudden multiple disorderly conducts, where if they attended a different school, I maybe never would have learned that child's name. So I don't know what that unevenness is, but we can see it on our end. And so I like the fact that we're going to start talking about these low-level disruption of schoolrooms and how to handle that. I think there's a need. I come from a family of teachers, so I can also speak to it from the teacher's standpoint, because we do talk to teaching groups that struggle with classrooms that are disruptive and how do you teach during the school day. So I think the intent of the bill is that the side us being like the zones or the courts, depending on which route you're going, with a lot of information. You know, is this child on an IEP? What services are they receiving? Is the school complying with the IEP? So I think we're meant, if we come in, either the zones or the court, to make sure that the schools, that the students' rights are being observed and that they're getting the services they need, and they're not just being arrested for a low-level misdemeanor in an inconsistent way. We've seen in my region, you know, that many of those low-level misdemeanors are so subjective. They depend on the arresting officer, and even the particular day. Can they reach a parent? Can the parent come and get them? Those are very subjective, and what you end up seeing is you see a lot of disparate impacts on minority youth. They tend to be arrested and referred at much higher rates for those things like disruption of a public school, disorderly conduct. And so I think in many ways, by the commission and the council and the children's cabinet taking a look at these, you know, it's just the beginning, but it's an important area that we need to start really kind of focusing on, so that we don't see a difference just based on what school district your child attends. So anyway, I could talk about that topic for a long time. So. And I'm not an expert on mobile crisis units. That would really be coming from DHS, but I think we all, I mean, I'm excited about it. I think we all need to hear more about it and how it's going to work in each region. So that would be a good future Teams meeting.
And so I see a mention of, maybe, I'm thinking this hasn't been discussed, but maybe having a community youth case manager to coordinate collaboration between stakeholders is maybe a future development.
Right. Mm-hmm.
I think
exactly.
To schools and how things may or may not be handled. At least the information that Karen has given you that we'll pass on through her PowerPoint has starting points if you want to research in. And as Lisa mentioned, I think maybe there's some school language that'll be popped back into the bill. So you can follow that as the bill changes and see how any changes might be made to things that would affect educational institutions. Karen, I think you also kind of spoke to urban rural settings and how this addresses how we figured out, or you figured out ways to maybe equalize the playing field. The last one that came in is, will the bill fund supplies for cultural activities so that Native American organization may deliver pro-social activities to Native juveniles to prevent juvenile activity?
Currently that isn't part of the bill, that fiscal, but I mean, I agree that we're trying to have more pro-social activities, and I think, you know, that's been the focus in the Fargo and Bismarck areas, where we've tried to really focus in on disproportionate minority contact, is to have more pro-social activities based on a youth's cultural background. But the direct answer to that question is no, that the bill doesn't talk about funding for services. I don't know if Lisa, this is not my bailiwick, but she's talking to someone, but I'm a practitioner, not a funder. But it'd be great if there was more. I'd like to see that. And I think that's coming with some of the Families First Act dollars, that there'll be more prevention dollars available up at the front of the system, so that you don't need to be funded by the court system and get into the courts to access those services. You shouldn't have to be arrested and have a court file to access a service. So I think that's the intent of those prevention dollars. But here too, I'm not the expert on that.
I'm sorry, Karen.
Yeah.
I mean, that was what, do you remember when I described the structure at the beginning of the Children's Cabinet, who has one side of their work is to build those behavioral health and then advocate for those kinds of supports. And certainly the work of the Juvenile Justice Commission, as we hear these things, we're reporting up to the cabinet about needs and issues and programs and services that we know are related to being able to successfully support kids and families as they shelter in place in our communities as opposed to continue to receive their services either out of their homes or in facilities.
And so I don't see any further questions, but I had one, and then I'm going to move it over to Carlotta. Speaking of racial disparities and inequalities in the system, can either of you, Lisa or Karen, speak to the diversity maybe for inclusion of racial discussion into this whole process? Like, were there other groups involved, and were those concerns brought out?
Well, I think specifically, we've already had questions about why would we take something out of federal law and place it into state law, but our specific concern was that we want to make sure that front and center in anything we do are responding to the Native American youth that live in our state and in our systems and that we have too much contact with already. So we deliberately shine the light on the Indian Child Welfare Act for that specific purpose. And again, as those conversations grow and spread and we gather the information around what is needed to support those children and families where they live, work, and play, we're hoping to really, that this is a starting point for us to really begin to achieve some parity and justice.
Wonderful, thank you. Okay, so with that, I'm going to kick it on over to Carlotta, our last presenter of the morning.
Good morning. So I'm going to start this off with a little bit of a personal story of raising a child that has mental health needs. When Garrett was 4 years old, he was given medication that caused some permanent damage for him and his ability to control his emotional regulation. If he was you had a stern voice or a different look in your face, he would go into a fight and flight response as a result of this medication issue that caused this damage. He later was diagnosed because it fit most closely with autism. So he was later diagnosed with autism, but he came about this at the age of 4. So a little bit different version of how you get autism. But again, he fits the diagnostic areas in that way. When Garrett was 5 years old, we were able to get him started into partnership services, and that was very helpful. Again, Garrett was probably having these meltdowns probably several times a day where he needed to be interrupted so that he would not hurt his other siblings or others. So again, very, very significant issues. When he started going to kindergarten, we talk about like the swears of a 4-year-old. He used to call me double fairy stepmother because I think Disney, the stepmothers are always horrible. And when he got to kindergarten, he learned a little bit more language to do a little bit better job of his swearing. And so when Garrett would become agitated, he would verbalize a lot of swearing and be very, very agitated. Garrett also was very upset with the word safety. That was one of his triggers. If somebody would use the word safety, he would agitate, start swearing. He might go into a fight and flight response. And oftentimes we think he associated the word safety with having to stop what he was enjoying and having fun with. So we finally got Garrett into kindergarten, and it took us about more than a half a year. He was in a segregated education setting when he was in kindergarten, and we finally got him into his neighborhood school. The principal, who was very, very nice and had spent a lot of time trying to get Garrett into his neighborhood school, and he also had a special education teacher who, again, was very, very welcoming and wanting him in, and actually tried to get him out of his segregated setting and into his regular classroom. So unfortunately, one day, the principal had gotten on the intercom and kids were not using the sidewalk to cross the street. So the principal on the intercom happened to use the word safety. And Garrett was just uncontrolled, and because he was wanting to run, he was fighting, and he was swearing quite a bit. Interestingly enough, when I got there to try and find out what was going on, his special education teacher, before she was able to tell me what had happened, Garrett told me that Mr. Baresh, his principal, had used the S word. He used the S word in front of everybody. And the S word was so bad, the word safety was so bad that he called it the S word because you couldn't possibly mention the word safety. He then proceeded to call his principal a foul curse word that did start with the letter S, but it was a full-fledged, he's this horrible thing. And so he's swearing at his principal and calling his principal swear words. And the principal came out to see if we needed help getting Garrett into the vehicle because, again, the flight risk that he proceeded. And we kind of got him in there. Thankfully, his special ed teacher and his principal kind of had a good sense of humor about it. That here Garrett is calling safety the S word, but yet he's cursing at his principal using a swear word starting with the S word that we all usually say he used the S word with. And so they had kind of a sense of humor about it, just how ironic it was, and were very accommodating for Garrett and just helping him calm down and getting through there. Then a few years later, I'm supporting some children who have been now arrested and charged because they were swearing in middle school. And now they're getting into the court system for the same thing. And so I'm supporting these kids, and we're trying to figure out how else we can do it. And the principal, had been on teams and things like that. And we had talked about all these. And he says, I know that they have special needs. I know that they have a lot of issues in that area. And he said, but the teachers are really mad. And I don't know what to do for those teachers if I don't charge the kids for their language. And he said, other middle school kids are swearing all the time, but they're not doing it in front of the teacher. And unfortunately for our children that have these needs, they can't necessarily choose where it's coming out or what's happening with it. So these children were being charged. The principal at the time then ended up being the superintendent later of the school, the assistant superintendent. And so he agreed to come to a program that we were trying to resolve around this issue. And anyway, we were talking about the issue about, Garrett's 5 years old, and it's really, it can kind of be looked at as being kind of cute, and people are accommodating. When he gets to be in middle school, again, not able to handle his swearing, what's going to happen to him when he's in middle school? Is he going to start racking up these charges with the justice system? And he said, well, we need to take a look at these kids that have special needs and in special education. They have disabilities, and we need to be accommodating. He ended up introducing himself. We talked about the problem, and sure to his word, the principal at the middle school said, yes, I have no choice other than to charge these students that are swearing. There just isn't anything else that I could possibly do. And so at that time, the now new assistant principal, a superintendent, got up and introduced himself as Rick Baresh, and he said, I'm also known as Mr. S because I shared the story of Garrett with the early swearing at his principal. And so he introduced himself and just kind of laughed and said, I'm also known as Mr. to Garrett. And he used the swear word there. And basically, we ended up with a resolve of being able to do crisis prevention intervention to all the teachers and staff so that they would have a way of de-escalating without charging children. And so there was a solution to it. There were other times I represented children who were in residential treatment facilities who had gotten upset and who had left the building. And again, I was working with a little 7-year-old who had ran out of the building because he got agitated, and he was in Manchester House, which works with the younger kiddos. And he was being charged at that time at 7. And of course, we've now raised the ages of who can be charged. But a little 7-year-old was being charged and brought into court. He was in a residential facility because of the fact that he had this significant mental health issue. And yet he was being charged for a symptom of his disability. And it didn't make any sense to me either. And again, I would bring up Garrett. He runs all the time because of his reaction to things. And it could just, like I said, a tone of voice could cause the fight and flight response to ensue. And so you didn't know. And so why are we charging children with these unruly charges when in fact it's really a symptom of their disability? And it didn't make any sense to me. And unfortunately, we've kind of done that a lot with the courts. We've had to do a lot of work around with the children that we're working with. And oftentimes, you know, they are being called and charged. You know, maybe something happens at school or whatever, and come to find out maybe the IEP wasn't followed, the procedure wasn't followed. And oftentimes it might be because there might be a substitute available at the time and they weren't aware. And so things got escalated and a child is being charged. So these are the things that have really been bothersome for families, is because they then have a child that's being charged. They have to go in through court. And oftentimes what we would do is really try and make sure that they were able to access services. Try and make sure that they were able to maybe get in partnerships for children to be able to access the services that they needed. And so it's really difficult when in fact you've got children being charged as a way of accessing services, or children being charged for behaviors that are a direct link to their disability, because people want to consequent them and say that they need to learn from these things. And you know, I find it really odd. You know, we don't charge somebody with diabetes if they go into it and have a diabetic reaction, but yet we're doing that for children who have a chronic mental health issue. So this, I would have to say, this is very welcome to families. The fact that children will now be able to access services, that we will be able to make sure that children don't have to go into court and go into the justice system needlessly. We know from research that children who are removed from the school and the education system, or the further that they're removed, the more likely they are to have some of the worst post-school outcomes. I mean, you look at some educational outcomes, the more that they're away from that neighborhood school, neighborhood classroom, they get separated or segregated, they get charges, they're less likely to finish school. They're less likely to be able to get jobs or go on to additional post-secondary education. Our outcomes for children with serious emotional disorder are some of the worst of any disability category that there is here in North Dakota. And in fact, I know they've done some educational reforms regarding that. So I do also know that right now, the prevalence rate for children with serious emotional disorder is about 18,000 children in North Dakota would have a serious emotional disorder. Yet, the Department of Human Services, our human service centers, who are our children serving agency for mental health, serve between 400 to 800 children. These are children in need of services. And schools need to have also access to children who have services and are being served so that they can be successful in their education environment. So I do believe it is about everybody, most especially our students, getting the services that they need. They have rights. They have there are Olmstead issues around children. We've got a lot of children that are ending up in YCC or the justice system. I think there is a huge disproportionate number of children where, I mean, at one point it was 79% of the children in juvenile corrections had a serious emotional disorder, and that had climbed from years. So if you look at the history of how that number has climbed, it is now coming down, which we're excited about. But I think that we have to do something, and I think this is going to be, we're very excited about this. that in fact children are going to be receiving maybe hopefully the services that they need, and that they aren't going to be getting into the justice system. One of the things that also impacts our children in the previous years would be a child has a parent, if they're needing to seek out-of-home treatment, children were able to, and parents were able to do a voluntary placement for their child. But if a child had been determined to be unruly or delinquent, they were no longer eligible for that voluntary treatment. Parents had to relinquish custody of their children in order to seek out-of-home treatment for a mental health condition. And so that is a huge consequence to children. And so one of the things that we have tried over the years, again, is to reduce the number of charges and findings on children who are really just children that are in need of services. I think that the other thing that we're concerned about, you know, when we're talking about the 400 to 800 children that are receiving services, families have had to rely on the justice system as a way to access any kind of services and supports. And so there is a concern for families on the flip side that if you take away their ability to access and the service system isn't up and really truly running and people aren't able to get access to those services that they need, is it going to just end up tying the hands of families and leaving them without any help whatsoever? And so that is something that really, really needs to be looked at. Right now, I know we have up and going our mobile crisis response. Right now, we have families saying that they aren't coming and doing that de-escalation in person. In the Bismarck area, we have lost Safe Beds, another service for children that would help again in having kids be able to remain at home. That is gone. So as we're expanding out, we're hopeful and optimistic that there will be more services. But when we stop some of these services with the mobile crisis, where we're not really getting that mobile crisis to be able to come in and properly de-escalate children, and we don't have access to services like Safe Beds, it is going to hamper what parents have the ability to do when they're in crisis. Many of the families in partnerships have had a crisis response plan. And in that crisis response, when a child has a behavior that ends up being in a crisis, I mean, there are crises that come up with our children with mental health needs. Their instruction is to call law enforcement. And that is very common. I would say it would be very unusual to not have call law enforcement on your plan. So again, we need to do something where we're actually providing the services that are needed and necessary for children and their families. And the justice system has been doing the best that they can. The education system has been doing the best that they can, but we need better and we need more. And we continually have delays in our children's system being developed for services. And that needs to really be developed more so that we don't have to continually to rely on the justice system. That school to prison pipeline is really strong here in North Dakota, unfortunately. And we need to do a better job for children that have mental health needs. So that's my soapbox.
And so, Carlotta, what I'm thinking as you end I'm hoping you're ended your,
Yes.
I'm not interrupting you.
Yes,
okay,
no.
so what I'm thinking is the question that's burning in my mind before we dig into the other questions is, are you excited about the doorways that this potential law can open up to a vast network of services being available? Like, is that something that gets you excited because you're very worried about this? And I get that.
So I think parents are worried about because there's a vacuum, and we saw we saw probably in the 2000s or whatever, a decline in mental health services and the number of children being served in our state. And we went into a mental health crisis as a result. I mean, so we do have this correlation of this drop in services. We need to have an increase in access to services. While we have the 1915I state plan amendment that's coming into place, those services are only available for a child that is on Medicaid. So normal, like our DD waivers, etc., if a child has a developmental disability, they gain access to Medicaid because of their disability. Children with mental health needs will not gain access to that unless they're already on Medicaid. And so that's going to be a little bit of a problem because we're putting all of our eggs in that basket of the 1915I. While it will serve children on Medicaid, and we're excited about that expansion, there are going to be children that are not going to gain access to those needed services. And so we're going to need to figure out how to deal with that. We are extremely excited about this bill. The stigma that is associated with children who have mental health needs is tremendous. We need to stop criminalizing a symptom of their disability. So we're extremely excited about this. Don't get me wrong, but we are going to have to do an awful lot of work to really absolutely ensure that the services are in place for these children that need the services.
Thank you, Carlotta. I think that's powerful for anyone who's interested to follow this along and lend their hand in any way that they can. I think you're a great resource for them. So with that, I'm going to dig into some of the questions that came in while you were presenting. There was a comment that sometimes in the IEPs, it's flat out written in, call law enforcement or take to detention, which speaks to exactly what you were speaking to of young children being arrested or put into the court system. Mobile crisis units, hopefully that they will be available to respond to some of these situations as they get off the ground and develop their services, I suppose. Let's see, what new services will be available because of this bill? Do you know, Carlotta, if it adds any funding for services not currently available? Or do you know if it eliminates any options for support for schools? Is there anything you're aware of at this point?
So it is my belief, and Karen and can kind of answer in on this a little, and Lisa can answer in on this a little bit, but I believe the services and supports are probably coming from the Families First legislation, which is really looking at being able to expand those services there. Then you also have, like I said, with the Behavioral Health Division, that inclusion of the 1915I state plan amendment, where they're really increasing services for children. Again, I think we're going to have to be careful with that gap for children that aren't on Medicaid. Not all of the children are on Medicaid that have a serious mental illness. And so we're really going to have to do something to kind of bolster that up so that we're ensuring that those kids are the kids that are not going to have access to services otherwise. And so that is going to be a huge gap that we need to fill fairly quickly for this to be successful. But I believe a lot of the services are going to be coming from those particular efforts rather than the bill itself.
Okay, next, somebody brought up that there is an issue currently in the system of children being discharged from placement, and that's an issue resulting in behavioral concerns have gotten them, and there's lack of concern planning and transition of these particular children affected by it. So that's definitely something for people to be aware of.
We also know that children have actually been charged while in those facilities and have been and probably a pretty strong referral source for
we actually started tracking it just a year ago. We started marking referrals from, I don't have it right at my fingertips, but I think it could have been as much as like 4 or 5% of our delinquency referrals came from placement facilities. And some of us literally just say no, like if they even think to call us ahead of time. But you're right.
Yeah. The other thing is that there is, and I've talked about this for years, but right now in our special ed funding formula, there is a fiscal incentive in place for schools to have agency placed children so that they can have the agency take care of the cost and the needs of that child, rather than doing it through the IEP process. So just so that you're aware, it's financially better for a school district that is having some problems to have an agency placed child rather than do that themselves. And we can get you that that information, but it has been, and it was years ago when I think Williston and some school districts sued the state regarding the funding formula, school funding formula. And so that was something that I really tried for, but I was really very, very outnumbered. But it should not be, we should not have any policies in place where it's financially more advantageous to have a child deeper in the system rather than keeping them in the community. It just will end up sometimes pushing those kids outward. So just know that for school funding, it is more advantageous for them to have an agency placed child rather than taking care of those behavioral health needs if they should need additional services.
Mm-hmm. Just so you know, too.
Bill change that? Sorry.
Pardon me?
Will this bill potentially change that, Carlotta? Do you think?
No.
Okay.
No.
I was just going to say, I pushed a little bit last year for the courts to enact or to adopt Rule 11.1 of the Juvenile Rules of Procedure, which is a rule based on child competency, because we had some schools who really wanted DD kids charged with delinquency for behaviors. And so we really did not have a statute or a rule about child competency. And we were seeing, parents who were frustrated and tired sometimes waiving rights to attorney, and then the kid not understanding and admitting to aggravated assault, just as an example. And so since October 1 of 2019, there is Rule 11.1 on child competency. And we have started using that, I wouldn't say aggressively, but it is a tool in cases where you need it. And Brenda knows exactly what I mean. We have used that out in the East. I'm not sure about the West, but we need to fight, those types of fronts where we see them for sure.
Mm-hmm.
Okay, before we run out of time here, Carlotta, there was a question for you to repeat the number of kids in North Dakota with mental health issues versus the number that are actually being served.
And I would say it's around 18,000 is a prevalence rate for a child with an SED. 18,000 children in North Dakota, and that's based upon prevalence rates. The children that were being served were between 400 and 800 by the Human Service Centers.
Thank you for repeating that. Okay, and then I think we're almost done here. Just a comment that went in, some concern about funding, DPI previously having to spend extra money to get the special ed budget for the last biennium, and looking at needs of funding for future sped budgets and concerns that are going to come out of this, making sure that everything's properly funded so everyone can do their job and maybe a little better,
Right.
This is just a base work, as I think everyone's kind of saying that there's a lot of room to build and grow here. And that's the message I'm taking away from it. Let's see here. Some compliments to our presenters. Great job. I'm going to add that in. And yeah, I don't see any other questions unless there's any final comments anyone would like to add from the presenters. I think we'll be done early.
I have one comment.
Sure.
I think that over the course of my 30-some years of working with at-risk kids and families in North Dakota, we've seen a steady or increasing amount of need for kids in schools, kids not in schools, just for kids and families. So the need has remained or grown, but the resources didn't. And so we found this back door in the justice system.
Mm-hmm.
And so really for many of us over the course of our entire careers, we've gotten used to this notion that this is a way to do something. but that doesn't make it right.
Mhm.
And so the effort here is to fix the foundation of the house, to give us the leverage for everyone to voice and push that kids and families are important and they need services, and they shouldn't have to beg, borrow, steal, or go to court in order to get what they need in order to support their children in their own homes. And so my plea is, don't attack the bill.
No.
Attack the absence and what has been an absence for at least 30, maybe 50 years. And let's fix that and put our energies together in that direction. And I know I pushed you to the end of your time now, so I'll shut up.
And I would also echo, I absolutely agree. This bill is something that's a long time coming, and I cannot be more excited about a major, major change for children. This is going to be a really big, big change. Change in how children are viewed is going to be just immense. And I think that we're going to start seeing better outcomes for our children as a result of this bill, not criminalizing them any longer. So I'm very, very excited about it.
Well, thank you. Thank you to our presenters. Thank you to everyone who attended. We will send out the PowerPoint and we'll have the recording available. And I got to say, I was excited before this, but I'm really, really excited now. So thank you for sharing your expertise and everyone weighing in. That was wonderful. Okay, with that, the webinar is concluded. I hope everyone has a fantastic day. Thank you.
Thank you.